All right, let's jump right in, folks. We've got a lot to cover today.
Definitely.
Some pretty big changes coming to California in 2025.
Yeah, definitely big.
Specifically to tenancy laws.
Right.
We're talking AB 2347 and SB 1103.
Two big bills.
So whether you're renting an apartment or running a small business, this is going to be important.
Yeah, you're going to want to know about this.
Because this is going to affect you.
Absolutely. And I think what's interesting here is that California is really focusing on protecting tenants, especially the smaller businesses and nonprofits.
Yeah, leveling the playing field a bit.
Yeah, who often don't have the resources to fight big legal battles with landlords, you know?
Right, exactly.
Yeah.
So we're seeing things like longer response times for eviction notices.
Right.
New rules for rent increases, even mandatory lease translations in certain cases.
Yeah, lots to unpack here.
So let's start with AB 2347
Okay.
and its impact on residential evictions.
Okay, so one of the biggest changes that AB 2347 brings is...
It's the extension of time that tenants have to respond to an eviction lawsuit.
Got it.
Previously, tenants only had 5 days.
5 days.
Which really isn't much time to
That's not a lot of time.
find a lawyer or gather evidence or even try to work things out with the landlord.
Right.
So this new law gives them 10 days.
Okay.
Essentially doubling that window of opportunity.
So that could really be a game changer for someone
Oh, absolutely.
facing eviction.
Yeah. It could mean the difference between losing their home or,
Right.
having a chance to fight for their rights.
Exactly. Yeah. And it also seems like the law recognizes
Yes.
that, not everyone gets served legal papers in the same way.
Exactly. So for those who are served by mail or through the Secretary of State's address confidentiality program, they get an additional 5 days on top of the 10.
Wow.
Recognizing that those methods can sometimes take a little bit longer.
So 15 days in those cases.
Exactly.
Okay.
Yeah. Makes sense. Makes
Yeah.
sense. The bill also kind of dives into some pretty technical legal procedures
What does?
around what are called demurrers and motions to strike.
Yes.
I am not a lawyer.
Right.
Can you break those down for me?
Of course. So think of it this way.
Yeah.
Imagine you're a tenant and you get hit with an eviction notice, but you believe that the landlord didn't follow proper procedure.
Okay.
Maybe they didn't give you proper notice.
Yeah.
Or the reason for eviction isn't valid.
Gotcha.
A demurrer is essentially a legal objection that you can file saying that the landlord's case is flawed,
Okay.
even if everything they claim is true.
So it's like saying, hold on, this eviction doesn't even make sense legally.
Exactly.
Okay.
Now, a motion to strike is a little bit different.
Okay.
It's asking the court to remove or strike certain parts of the complaint that are irrelevant
Gotcha.
or improper or legally unsound.
Okay.
So maybe the landlord threw in some accusations that are just meant to be inflammatory and have nothing to do with the eviction. A motion to strike aims to kind of clean up the legal arguments, so to speak.
I see. Okay, so AB 2347 clarifies how and when these motions can be used
It does.
in eviction cases.
Yes.
What impact do you think that'll have?
Well, it lays out clear deadlines for these motions,
Okay.
ensuring both sides have a fair chance to present their arguments.
Okay.
So, for example, if a tenant files a demurrer or a motion to strike,
Yeah.
the hearing has to be scheduled within 5 to 7 court days.
Got it.
And there are new rules for written oppositions, requiring them to be filed the day before the hearing.
Okay.
But, and this is crucial,
Yeah.
the court has the discretion to consider oppositions even if they're filed late.
Okay, so there's a little bit of flexibility built in there,
Exactly.
which I imagine could be really helpful
Yeah, very helpful.
for, tenants who are struggling to kind of navigate this legal system.
Absolutely.
But even for those who aren't facing eviction right now,
Right.
these changes seem significant.
Absolutely. It signals a shift in California law towards strengthening tenants' rights and making sure that they have a fair shot in defending themselves
Yeah.
in eviction proceedings.
It's about creating a more balanced system.
Exactly.
Okay, so we've seen how AB 2347 is giving residential tenants more time and more legal tools to fight evictions.
Yes.
But what about those renting commercial spaces?
Right. That's where SB 1103 comes in.
Okay, that's right.
Yes. And this is a game changer for commercial tenents,
Uh-oh.
especially those categorized as qualified commercial tenants,
Okay.
which specifically includes micro enterprises,
Got it.
small restaurants, and nonprofits.
Interesting.
These groups often lack the legal muscle of larger corporations.
Right.
So these protections are crucial for them.
Makes sense.
Yeah.
One of the things that jumps out to me is this new requirement for
Yes.
rent increase notices.
Uh-huh.
Can you tell us more about how that works?
Sure. So under SB 1103, landlords are now required to give qualified commercial tenants more notice before any rent increase takes effect.
Okay.
If the increase is 10% or less, it's a 30-day notice.
Okay.
But if that increase goes above 10%,
Mm-hmm.
landlords have to give tenants a full 90 days.
Wow. That's a big difference.
Huge difference.
And I imagine that extra time could be really crucial
Oh, absolutely.
for a small business owner trying to adjust their budget
Right.
or, potentially renegotiate their lease.
Yeah, absolutely.
It seems like it could prevent a lot of,
Yeah.
financial hardship.
A lot of financial hardship, and it's important to emphasize that this applies to existing leases as well,
Oh, wow.
not just new ones,
Okay.
signed after the law goes into effect.
So this provides some
Right.
much needed stability, I imagine.
Absolutely, for tenants who might have signed leases before these protections were in place.
Gotcha. That's a big win for tenants for sure.
Absolutely.
Now, another change that kind of caught my eye was this part about lease translations.
Yes.
This seems particularly relevant in a diverse state like California.
It's a critical step towards fairness and transparency.
Yeah.
Imagine being handed a complex lease agreement in a language you don't fully understand.
Right.
It can feel very overwhelming and disempowering.
Right. Absolutely.
So SB 1103 addresses this by requiring landlords to provide a translation of the lease
Okay.
if it was negotiated primarily in a language other than English.
Okay.
And this applies specifically to Spanish, Chinese, Tagalog, Vietnamese, or Korean,
Got it.
reflecting the demographics of the state.
Okay. So if a tenant primarily speaks one of those languages
Right.
and negotiated a lease in that language, the landlord is legally obligated to provide a translated version.
They are.
What happens if they don't?
If the landlord fails to provide the translation, the tenant actually has the right to rescind
Okay.
the lease.
Interesting.
Meaning they can cancel it. It gives tenants a powerful tool to ensure they fully understand what they're agreeing to.
It sounds like SB 1103 is really putting some teeth behind these protections.
Yes, it is.
Making sure that they're not just
Right.
empty words on paper.
Exactly, and it doesn't stop there.
Okay.
The bill also tackles lease termination,
Okay.
bringing it more in line with residential tenancy rules.
Can you explain what that means in practice?
Sure.
What are the new rules around ending a commercial lease?
So traditionally, leases are considered to be automatically renewed
Right.
unless one party gives written notice to terminate.
Okay.
SB 1103 sets clear guidelines for those notices,
Got it.
mirroring the rules for residential leases.
Good.
For leases under a year, landlords need to give at least 30 days notice.
Okay.
But if the lease is for a year or more, that jumps to a 60-day notice.
Wow. So no more surprise lease terminations.
Exactly.
Or, scrambling to find a new space.
Right.
With very little time to spare.
Exactly. It gives businesses that predictability that they need.
Right. Especially smaller ones.
Yes.
They need that predictability to operate successfully.
Absolutely, yeah. You're right on the mark. It's all about providing that stability and preventing landlords from pulling the rug out from under their tenants without sufficient warning.
All right. Okay. So we've covered a lot of ground just with those two aspects of SD 1103.
We have.
Rent increases and lease terminations.
Yeah,
But there's one more big piece of the puzzle
there is.
that we need to kind of explore here, and that's this part about building operating costs.
Yes,
This seems like it could be a major point of contention
it definitely is.
between landlords and tenants.
Yes, it's an area where we've seen a lot of disputes in the past.
Okay.
Landlords sometimes try to pass on all sorts of operating expenses
Right.
to tenants, sometimes without proper justification or transparency.
Okay.
So SB 1103 aims to address that head on,
Got it.
putting some serious limitations on how landlords can handle those costs.
So let's unpack that. What exactly are these new restrictions?
Okay.
And how do they protect commercial tenants?
So the key here is transparency and fairness.
Okay.
Landlords can't just lump all sorts of operating expenses onto their tenants
Right.
without providing a clear breakdown
Yeah.
and documentation.
Okay.
Those costs have to be allocated proportionally based on factors like the square footage that the tenant occupies.
Ah.
And landlords are required to keep detailed records to support those charges.
Oh, So no more vague fees or hidden charges.
Exactly. Landlords have to show their work, so to speak.
Okay. And what happens if they don't?
If a landlord tries to charge operating costs without providing proper documentation, the tenant can actually refuse to pay that fee.
Really?
And if they're taken to court for non-payment, they can use the landlord's lack of transparency as a defense.
So it's not just about having rights on paper.
Exactly.
It's about having the tools to actually enforce those rights.
Exactly.
And as we mentioned before, the potential penalties for landlords who violate these provisions are pretty significant.
They are. We're talking potential damages, attorney fees, and even punitive damages.
Right.
If the court finds that the landlord acted intentionally unfair or malicious,
that's pretty hefty.
The legislature is sending a clear message here. These tenant protections are serious business.
Right.
And there will be consequences for violating them.
It definitely seems like California is taking a strong stance to protect tenants.
It is. And for our listeners, whether you're a seasoned entrepreneur or thinking about starting a small business, these changes could make a big difference down the road.
Right.
They provide crucial protections against unfair practices and help to create a more stable and predictable business environment.
Okay, so we've covered a lot of ground in this first part of our deep dive.
We have.
AB 2347 focuses on giving residential tenants more time and a fairer shot in eviction proceedings.
That's right.
While SB 1103 throws a lifeline to those qualified commercial tenants. By protecting them from unfair rent increases.
That's right.
Shady lease agreements and hidden operating costs.
You got it.
So.
And while these changes might seem a little overwhelming at first glance, the overarching message is clear. California is moving towards a system that prioritizes fairness and transparency for both residential and commercial tenants.
And remember, folks, knowledge is power.
It is.
Staying informed about these changes can help you navigate your own tenancy.
Absolutely.
Whether you're renting an apartment or running a business.
That's right. Excellent point. And if you find yourself needing specific legal advice, consulting with a qualified attorney is always the best course of action. They can help you understand how these new laws apply to your individual situation.
We're just about out of time for this part of our deep dive. But before we move on to the next section, I want to leave our listeners with this thought. Do you think these changes strike the right balance between landlord and tenant rights?
That's a good question.
What other changes might be needed in the future?
Food for thought.
And hey, you've just completed the first part of our deep dive.
You have.
You're already ahead of the curve.
That's right.
We'll be back soon to explore the potential impact of these laws. And what they might mean for the future of housing in California.
Sounds good. You know, it's interesting to think about the potential ripple effects of these new laws. They could have a significant impact on the dynamics between landlords and tenants, even beyond the specific provisions that we've talked about.
I'm curious about that. What kind of shifts do you anticipate seeing as these laws go into effect? Do you think it'll lead to more disputes, or could it actually encourage more
That's a great question.
cooperation between landlords and tenants?
It's hard to predict with certainty, but I think we could see both scenarios play out. On the one hand, some landlords might push back against these new regulations, leading to more legal challenges and disputes.
That wouldn't be surprising.
They might try to find loopholes or test the boundaries of these laws.
Change can be unsettling, and some people are always going to resist it.
Exactly. But on the other hand, I think these laws could also foster a more collaborative and transparent relationship between landlords and tenants. When both parties have a clear understanding of their rights and responsibilities, it can create a more level playing field and encourage open communication. Tenants might feel more empowered to assert their rights, and landlords might be more inclined to work with tenants to resolve issues before they escalate.
Exactly,
into legal battles.
So if these laws lead to more transparency and accountability on both sides, it could create a more stable and predictable rental market, which benefits everyone in the long run.
Exactly. It's all about finding that balance between protecting tenants' rights and ensuring that landlords can operate their businesses effectively. These new laws seem to be aiming for that sweet spot. And it'll be fascinating to see how things play out in practice.
Speaking of seeing things play out in practice, let's kind of circle back to that part of SB 1103 that deals with building operating costs.
Okay.
We talked about the new requirements for documentation and
Yes.
proportional allocation of costs. But I'm still a little fuzzy on how tenants can actually use those provisions to their advantage.
Okay, so let's break it down with a hypothetical scenario.
Okay.
Imagine you're a small business owner renting a storefront.
Okay.
You get your monthly bill, and you notice a significant increase in operating costs.
Mm-hmm.
But the landlord hasn't provided any breakdown or explanation for the increase.
Okay.
In the past, you might have just grumbled and paid the bill, not wanting to rock the boat.
Right.
But under SB 1103, you have a new option.
So instead of just accepting that increased cost, the tenant can push back and demand more information.
Precisely. You can request documentation from the landlord outlining exactly what those operating costs are,
Okay.
how they're calculated, and how they're allocated proportionally to your space.
Okay.
And here's the key. The landlord can't start charging those increased operating costs until they've provided you with that documentation.
That's a pretty powerful tool for tenants.
It is.
It puts the burden of proof on the landlord to justify those costs.
Exactly. And if the landlord fails to provide that documentation, you as the tenant can refuse to pay the increased fee.
Wow.
And if they try to evict you for non-payment,
Yeah.
you can use their lack of transparency as an affirmative defense in court.
So it's not just about having rights on paper.
Exactly.
It's about having the tools to enforce those rights.
It is. And as we mentioned before, the potential penalties for landlords who violate these provisions are pretty significant. Those potential damages, attorney's fees, and even punitive damages in some cases, send a strong message that these tenant protections are to be taken seriously.
It really does seem like the California legislature is trying to create a more level playing field between landlords and tenants.
That's a great way to put it. It's not about demonizing landlords or tilting the scales unfairly.
Right.
It's about promoting fairness, transparency, and accountability in the rental market.
And ultimately, I think that benefits everyone involved.
It does.
A more stable and predictable rental market
Absolutely.
is good for tenants and landlords alike.
I couldn't agree more.
Yeah.
It fosters trust, encourages open communication, and helps prevent those unnecessary disputes.
Okay, so we've unpacked both AB 2347 and SB 1103.
We have.
We've talked about the specific changes they bring and how they impact both residential and commercial tenants here in California.
We have.
And we've delved into the potential ripple effects of these laws and how they could reshape the dynamics between landlords and tenants.
That's right.
Now, I want to shift our focus a bit and talk about the broader context of these changes.
Okay.
What do these laws tell us about California's approach to housing policy? Are we seeing a shift in priorities, a move towards greater tenant protection?
That's an astute observation, I think. These laws signal a growing recognition that housing is more than just a commodity.
Right.
It's a fundamental human need, essential for stability, well-being, and economic opportunity.
And with that recognition comes a responsibility to ensure that housing is accessible, affordable, and equitable for all Californians.
Precisely. These new laws, while not a silver bullet solution to the state's complex housing challenges, represent a step towards a more just and equitable housing system. They acknowledge the power imbalance that often exists between landlords and tenants, and they aim to level the playing field.
It's interesting to think about how these changes might ripple outward, influencing not only the legal landscape, but also the social and economic fabric of California communities.
Absolutely.
We might see more stable neighborhoods, more thriving small businesses, and a greater sense of security for tenants.
Absolutely. And it'll be fascinating to see how these new laws are implemented, interpreted, and ultimately impact the lives of both landlords and tenants in the years to come.
We've covered a lot of ground today.
We have.
From the nitty-gritty details of AB 2347 and SB 1103 to the broader implications for California's housing future.
That's right.
But before we wrap things up completely, I want to bring it back to our listeners.
I agree. It's important to connect these legal changes to the real-world experiences of people navigating the rental market.
So for those of you listening, whether you're a tenant, a landlord, or just someone who's interested in housing issues, we want to hear from you.
We do.
What are your thoughts on these new laws? Do you think they'll make a difference in your community?
Good question.
Share your perspectives in the comments, and let's keep this conversation going.
This has been a really insightful discussion.
Yeah, for sure.
We've covered a lot of ground.
Yeah, we have.
From the specific provisions of these new laws to their potential impact on the California housing landscape.
I feel like we've only just scratched the surface.
We have. There's so much more to explore.
Yeah, definitely.
When it comes to the complexities of housing and tenants' rights and the role of legislation in shaping those dynamics.
It's an ongoing conversation.
It is.
For sure.
And one that requires us to stay informed, engaged, and willing to consider different perspectives.
Well, for our listeners who have joined us for this deep dive.
Yes.
You're already taking that first step.
You are.
Towards understanding these crucial issues. And hopefully you're feeling a bit empowered.
Yes.
To navigate the rental market.
Yeah.
With a greater sense of knowledge.
Absolutely.
And confidence.
Knowledge is power.
It is.
Especially when it comes to legal matters that can have such a profound impact.
Yeah, for sure.
On people's lives.
Whether you're a tenant facing an eviction or a landlord trying to understand your new obligations.
Right.
Or simply someone who's interested in housing policy.
Yes.
Staying informed is key.
Absolutely. And remember, we've only been able to give you a broad overview of these new laws.
Yeah, it's a lot to cover.
The specifics of how they apply to your individual situation can vary. So it's always a good idea.
Yeah, always a good idea.
To consult with a legal professional if you have specific questions or concerns.
Couldn't agree more.
Yeah.
Okay, before we wrap things up completely, I want to leave our listeners with a final thought-provoking question.
Right.
We've talked about the letter of the law.
Yes.
But what about the spirit of the law?
Okay.
What do these changes tell us about the direction California is heading in when it comes to housing policy?
That's a perceptive observation.
I think it signals a growing recognition that housing is more than just a commodity.
Yeah.
It's a fundamental human need.
It is.
And with that recognition comes a responsibility.
Absolutely.
To ensure that housing is accessible, affordable, and equitable.
It does.
For all California.
Precisely. These new laws, while not a silver bullet solution to the state's complex housing challenges, represent a step towards a more just and equitable housing system.
It's inspiring to think about.
It is.
The potential positive ripple effects of these changes.
Yeah.
More stable communities, thriving businesses, and a greater sense of security for renters.
Absolutely. And it will be fascinating to see how these new laws are implemented, interpreted, and ultimately impact the lives of both landlords and tenants in the years to come.
Well, that's about all the time we have for this deep dive into California's changing tenancy laws.
Right.
We've covered a lot of ground.
We have.
But we hope you found this exploration informative and engaging.
It's been a pleasure sharing these insights with you.
It has been great, as always.
And our listeners.
And remember, the conversation doesn't end here.
It doesn't.
Stay informed, stay engaged, and continue to advocate for a housing system that works for everyone.
Well said. Thanks for joining us on this deep dive.
Absolutely. And we'll see you next time.
Call now 714-442-9741. Thank you.